Well, sir, are you Francisco Garcia?
Yes.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Right away, we're seeing a defendant facing two separate felony charges: burglary of a habitation and threatening to publish intimate visual material. Those are very different allegations, but both carry serious consequences. Watch closely here, because a guilty plea isn't just admitting wrongdoing, it's also giving up several constitutional rights, including the right to a trial.
Mr. Garcia, in cause number 25 DCCR 0900, you're charged with the second-degree felony offense of burglary of a habitation from March 24th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0901, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from March 13th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with? I'm sorry.
Yes, ma'am. Sorry.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement in the first case, 0900, is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, which includes having no contact at all with Melissa Escalera and, is that Jose Landa?
Yes, Judge.
And to delete or destroy any intimate or private photos, and allow your probation officer to inspect any devices, your phone or any devices at your home. Do you understand?
Yes, ma'am.
Your Honor, if I may, I neglected, I just realized I wrote those down as conditions in the burglary case, but not in the publishing case. The intent of the parties was that there be conditions in both cases.
Sure. You understand that'll be your conditions of probation in both of your cases, correct? And then in 0901, the agreement also is for that 5-year deferred probation, a $500 fine, and all of those other conditions that I've already gone over.
Yes.
Is that your understanding as well?
Yes.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing.
This is a major moment that many viewers might overlook. The judge isn't just handing down probation, she's attaching highly specific conditions: no contact with the alleged victims, destruction of private images, and even allowing probation officers to inspect electronic devices. That's the court trying to prevent future harm while keeping the defendant out of prison.
So the probation department can do a pre-sentence report. They'll give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom today and talk to probation. She's sitting at that desk right over there. All right, we'll see you back at sentencing.
Thanks, Judge.
Thank you. See, Mr. West, you've got Jeremiah Douglas. Morning.
Morning.
Got it. Good morning, sir. Are you Jeremiah Douglas?
Yes.
And will your client waive the formal reading of the indictment in each case?
Yes, please, Your Honor.
Notice what just happened. Even though the court accepted the guilty plea, sentencing isn't happening today. Instead, the judge ordered a pre-sentence investigation report, often called a PSI. Think of it as a deep background check that helps the court decide whether the defendant is truly a good candidate for probation.
Mr. Douglas, in cause number 25 DCCR 1115, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from July 27th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 25 DCCR 1222, you're charged with a second degree felony offense of fraudulent use or possession of identifying information between 10 and 50 items, and that's from July 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they charged you with. In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. West?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And so it looks like the agreement in 1115 is for a 5-year deferred probation, a $500 fine, and any other conditions subject to the pre-sentence report. Is that correct?
Right, yeah.
That was
Is-
primarily to entail a forfeiture in the UCW misdemeanor.
Okay, so as part of these plea agreements, that he's going to take care of the unlawful carrying a weapon and forfeit that. Is that correct? Is that your understanding as well? And then in cause number 1222, it's the same agreement, which is for a 5-year deferred probation, a $500 fine, and obviously the same conditions of probation, and also that you would take care of that unlawful carrying a weapon and forfeit that weapon. Is that your understanding? Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Douglas is not competent?
No, ma'am, not at all.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom today to talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Yeah, I need
I'll send it to you.
sign it. You have to
Yeah.
sign his right now.
Yeah, I mean, that's it right now.
And I need it emailed. It has to be emailed today.
Yeah, I will. There you go.
Mr. Galmore, you've got Lance, Laura.
Morning, Judge.
Good morning. Good morning, sir. Are you Lance, Laura?
Yes, ma'am.
And this is 25 DCCR 1912. Mr. Laura is charged with failure to comply with sex offender registration requirements. Mr. Galmore, what is the announcement?
Judge, we're asking for one last announcement day. We're gonna have him come in and look at some discovery with me, and we'll be ready to do either announce trial or cruise off in case the next setting.
Any issues?
No, you're
All right, this will be the last reset. It looks like you were hired in January, so that'll put us about 7 months out. You need to make sure, make an appointment, go visit with Mr. Galmore, so you guys are ready to make that announcement at the next board date.
Yes.
Okay, see you then.
Thank
Thank you. And have we seen Mr. Gertz? Mr. West, you got Miguel Reyna.
Yes, Your Honor.
Good morning, sir. Are you Miguel Reyna?
Yes, ma'am.
This is 25 DCCR 1687. Mr. Reyna is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, if we can get, we're still working through our contractor obligations. We're getting close to the finish of that. I don't believe this is super old. If we can get another resetting.
This will be the last reset. It looks like you were hired in January.
Yes,
So Mr.
yes.
Reyna, make sure you stay in touch with Mr. West
Okay.
because you guys need to visit before that court date. Take care of whatever you're supposed to because we have to get an announcement that next court
And he's
date.
been in good communications. That's not an issue.
All right, we'll see.
Make sure that it's still not driving.
Mr. Reyna,
Yes.
you're not driving, correct?
He is, but he has an interlock device. He had just recently paid for. He sent me a copy of the receipt.
Okay.
It's updated.
Make sure you don't drive any vehicle that does not have that interlock device on
He's very
it.
careful about it. He's always.
Okay. Okay,
To me, every month he tells me.
And now we're moving into another case with a completely different set of allegations. Evading police with a vehicle and possessing large amounts of identifying information can raise concerns about public safety and potential identity theft. Yet once again, the defendant is seeking deferred probation instead of immediate incarceration. The question is, will the court believe rehabilitation is the better option?
all right, we'll see you back at sentencing. Do you have those certifications
I'm
done?
about to get the false number on him, Your Honor. This only I don't have right here, but.
Okay, then there you go. I'll get that email to you today.
Thank you. Mr. Gertz, you've got John Jackson's sentencing.
Good job.
Morning, Judge.
Good morning.
How are you?
Good. How about you?
Good. Pleased to see there's not a bunch of highlighter on there.
Yeah. This is Mr. Smith's sentencing. Sorry. It's John Jackson.
Yeah, see.
All right, sir, are you John Jackson?
Yes, Your Honor.
This is 24 DCCR 1968. Mr. Jackson was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I've received the pre-sentence report. Have you both had an opportunity to review the report?
Head Judge.
Judge, sorry, I have all Mr. Smith's files organized. I can just grab it real quick because he had a couple things happen.
Okay.
We have one, I've called clerical correction, Judge.
I'll defer to Mr. Gertz first, Judge.
Go ahead.
On page 3, under monthly expenses. When Mr. Jackson filled out the monthly expense amount, he inadvertently left off taxes that he has to pay. And so he would say his expenses are $983 for investments.
All right.
We have no other corrections, objections, or changes.
Thank you.
And we're
Ms.
asking
Malvino.
to follow the agreement.
Thank you, Mr. Gertz.
Judge, I'm obviously aware of the case after review of the PSI and in discussion multiple times with Mr. Smith about it. And I believe the concern the state would have would be the comments made in the defendant's version. But we'll defer to the court with whatever you deem is appropriate for final resolution.
So it gave me some current concern also, Mr. Jackson, about the level of responsibility that you are taking about what happened that day. Obviously, you understand that what happened that day is not how you handle any type of situation like that. Do you understand? All right, sir. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those is that you are not allowed to possess a firearm at all. Do you understand? That's in your home. No one else can have one. No access to any firearms. You understand?
Yes, Your Honor.
Also, there's going to be a mental health evaluation just to see if there's any issues that need to be taken care of while you're on probation so that they can give you whatever help you need to be successful. If you do everything that you're supposed to while you're on this probation, it's a great opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for anywhere between 2 years and up to 20 years.
Here's a detail that shouldn't be ignored. The judge is emphasizing the ignition interlock device, a system that prevents a vehicle from starting if alcohol is detected. Courts take DWI violations extremely seriously, and driving without the required device could create even bigger legal problems down the road.
Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up when she's ready to go over your paperwork. All right. And then, Mr. Gertz, you've got Eric Landry.
But hold on that.
Sure.
This may be the most important lesson of the entire hearing. Deferred probation can feel like a second chance, but it's also a tightrope. Successfully complete it, and the defendant avoids a felony conviction. Violate the rules, and the court can revoke that opportunity, entirely opening the door 2 years in prison. What do you think? Is deferred probation the right balance between accountability and rehabilitation?